Reading law, in Roe versus Wade, the Supreme Court declared unconstitutional state statutes that in no way contradicted any specific provision of the Constitution, close quote. Second quotation, Justice Blackmun, 1973 opinion itself. The right of privacy, whether it be founded in the 14th Amendment's concept of personal liberty, or as the district court determined in the 9th Amendment's reservation of rights to the people, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy, close quote. So Justice Blackmun, writing for the majority, takes pains to ground the court's decision, well, I suppose you could, in the 14th and the 9th, or if you read his opinion carefully, it's the 14th or the 9th, you get to choose. And he's wrong.
Did he say the 14th? Or
he said the right of privacy, whether it be founded in the 14th Amendment's concept of personal liberty, as we feel it is, or as the district court determined in the 9th Amendment's reservation of rights to the people.
Well, once again, this is one aspect that the book addresses. When you have terms in the Constitution that are not ambiguous in the sense that they can mean one of two things, but rather are general, so that they could cover a lot of things. You should interpret them not to cover the things that the people who adopted that provision did not think they covered. And, you know, cruel and unusual punishments is one. Of course, those words could cover a lot of things, but it's clear from the history of the times that nobody thought that it included the death penalty. Nobody. And it's the same thing with this right of abortion, whether it's founded in the 14th or, I mean, God, the 9th Amendment, forget about it. Nobody ever thought that, I mean, just look at history. All the states had prohibitions on abortion for hundreds of years. So when was it that the American people made the decision to forbid a state from adopting such?
They never did.
They never did. The court made it up. And you know, we're not talking about the right or wrong of the substantive result. I mean, I'm quite, neutral on that. The point is, who should decide? Should it be a question on abortion, whether people try to persuade each other that there ought to be, there oughtn't to be, and put it to a vote? That's fine. That's, if you want the right to abortion, create it the way most rights are created. In a democracy, you persuade your fellow citizens, pass a law. You want to abolish the death penalty, the same thing. But all of that democratic choice is taken away when the court is enabled to give vague provisions such as due process of law, equal protection of the laws, meanings that they did not have when they were adopted.
How it should be done.